The First Amendment is probably the most misunderstood law in America. People invoke it constantly when they get banned from social media, when their employer fires them for a tweet, when a private business asks them to leave. But here is the thing most people do not realize. The First Amendment only protects you from government censorship. That is it. The text reads that Congress shall make no law abridging freedom of speech. Congress. Not Twitter, not your employer, not the owner of a restaurant. Private entities can absolutely restrict your speech and face no constitutional consequences whatsoever. This is the single most important thing to understand about the First Amendment, and the number of people who get it wrong is staggering. This is legal education, not legal advice. Always consult an attorney for your specific situation. So what speech does the government actually protect? The Supreme Court has carved out a robust but not unlimited zone of protected expression. Political speech gets the highest protection. You can criticize elected officials, protest government policy, even burn the American flag as a form of symbolic protest. Texas versus Johnson in 1989 and United States versus Eichmann in 1990 both confirmed that flag burning is protected expression, even though many Americans find it deeply offensive. Offensive speech is generally protected. Hateful speech, while morally reprehensible, is broadly protected in the United States in a way that surprises many people from other countries. The Supreme Court has repeatedly struck down hate speech laws as unconstitutional, most recently in Madel versus Tam in 2017. But there are categories of speech that fall completely outside First Amendment protection. True threats are not protected. If you tell someone you will kill them and a reasonable person would take it seriously, that is a crime. Incitement to imminent lawless action is not protected, under the Brandenburg versus Ohio standard from 1969, which requires the speech to be directed at producing and likely to produce imminent illegal action. Notice how high that bar is. It has to be imminent, not just theoretically dangerous someday. Obscenity, as defined by the three-part Miller test from Miller versus California in 1973, is not protected. Neither is defamation, false statements of fact that damage someone's reputation, child sexual abuse material, fraud. These are all outside the constitutional protection. The Citizens United v. FEC decision in 2010 extended First Amendment protection to corporate and union political spending, treating money as a form of speech. In a 5-4 decision, the court held that corporations and unions have the same right as individuals to spend money on political messaging. This was enormously controversial and is frequently misunderstood. Citizens United did not allow direct contributions to campaigns. That is still regulated. It allowed independent expenditures, meaning organizations can spend unlimited money on ads as long as they do not coordinate with a campaign. The decision fundamentally changed the landscape of campaign finance and remains one of the most debated constitutional rulings in recent history. The public forum doctrine is another crucial piece of First Amendment jurisprudence. Traditional public forums, streets, parks, public squares, get the strongest speech protections. The government can impose reasonable time, place, and manner restrictions, but cannot ban speech based on its content. Designated public forums, like a school auditorium open to community groups, also get strong protection. But non-public forums, like a government employee's office or a military base, can have much tighter restrictions. This distinction matters enormously when it comes to protests, demonstrations, and whether you can hand out leaflets in a given location. Here is a practical summary of what the First Amendment actually means for your daily life. Your employer can fire you for your speech. Your social media platform can ban you. A private university can punish you for offensive statements. None of that is a First Amendment violation. The government, however, cannot arrest you for criticizing the president, cannot ban books from public libraries without very strong justification, cannot stop you from peacefully protesting on a public sidewalk, and generally cannot tell you what you can or cannot say. Understanding this distinction between government and private actors is the key to understanding what the First Amendment actually does and does not protect. Remember, this is legal education, not advice for your specific situation.